Welcome to my channel. I'm Deborah Gray. I'm a journalist and I cover a variety of socio-political and human rights issues. Today, once again, let's dive right back into marriage equality. On May 11, after 10 days of hearings, a special constitution bench of the Indian Supreme Court reserved its judgment in the marriage equality case. In my previous videos, I have spoken about who is opposed to marriage equality and why. I've also touched upon some of the arguments that they have presented before the court so far. Now, let's take a look at the arguments presented by the petitioners. Let us begin with Senior Advocate Mukul Rohatgi, who eloquently argued that it doesn't matter if the size of the LGBTQIA+ community isn't large. What matters is that every Indian citizen, irrespective of their gender or sexuality, is treated with the same amount of dignity and respect. He said, and I quote, "We may be a minuscule minority, but having the same rights, we are entitled to the same declaration." End quote. He also emphasized the need not to depend solely on the Parliament and why the court's intervention was necessary to end the stigma, saying, "Sometimes mindsets do not change. Parliament or the Legislative Assembly sometimes acts with more alacrity, sometimes with less." Navtej was 5 years ago. In 5 years, we've seen the change. Some stigma is still there. That stigma can only be removed with the declaration, just like a declaration was made in Navtej. Senior Advocate Geeta Luthra is representing a couple that is legally married in the United States, but not in India. Now, if you remember, during COVID, spouses of Indian citizens were granted Indian visas. But this couple was denied that privilege only because they're a same-sex couple. Advocate Luthra said, and I quote, "It is discrimination on the grounds of sex, same way that in many parts of the world, women were not given the right to vote on the basis of their sex. There is no distinction." She went on to say, and I quote, "Marriage is an expansive, evolutionary, inclusive concept. At one time, interracial marriages weren't recognized in the United States. In India, intercaste marriages were not recognized." Now, I find this to be a very powerful argument in favor of allowing the law to evolve with the times. Next up was Senior Advocate Jaina Kothari representing Dr. Akkai Padmashali. Senior Advocate Jaina Kothari reminded the court about the concept of family as it applies to transgender people. She said, and I quote, "Trans persons are already having families. They're in relationships, adopting children, but these families are not recognized." She went on to ask, "Is a family different just because your gender identity is different? Are these not the same values that all of us want at the end of the day?" She proposed a gender-neutral reading of the Special Marriage Act. Senior Advocate Menaka Guruswamy argued against the government's stand to let the Parliament decide on granting marriage equality. She said, and I quote, "Marriage is not only a question of dignity, it is also a bouquet of rights that the LGBTQ people are being denied." She also reiterated, "The Indian Parliament is a creature of the Constitution and does not enjoy unfettered powers." Advocate Arundhati Kajju, who is also Senior Advocate Menaka Guruswamy's partner, kept her argument to the point and very succinct. She said, and I quote, "We seek first a positive declaration that marriage solemnized under the Special Marriage Act and parties to such marriage will be entitled to all rights and obligations notwithstanding gender identity and sexual orientation. We also seek a negative declaration binding the state to not deny rights and obligations to married couples whose marriage has been solemnized under the Special Marriages Act, only on the grounds of sexual orientation or gender identity." Senior advocate Raju Ramachandran brought to light the case of a lesbian couple. While one of them is a Dalit woman from Punjab, another belongs to a backward class from Haryana. He used this to demolish the government's argument that the demand for marriage equality was an urban elitist concept. He said, and I quote, "The mere presence of these two petitioners and similar petitioners should put down the glib assumption made in the government's affidavit that they are urban elite. That statement was careless, unnecessary, and insensitive." He highlighted the threats faced by such couples from their own families, saying, "The institution of marriage is not just the gateway to various socio-economic rights, but it is a societal protection from their own natal and parental families. Such couples do not have enlightened parents, they don't have understanding families." Senior advocate Abhishek Manu Singhvi made his stand clear. He said, and I quote, "We do not seek a declaration of right to marry, but a right to marry under the Special Marriages Act by an interpretation of the SMA which will allow the solemnization of non-heterosexual marriages." End quote. He reiterated, "The relief I seek is workable and neither requires this court to create a new social institution, nor does it require to have a new definition of marriage. Thirdly, it doesn't require you to enter into any thicket of personal laws or other related laws." End quote. Now, these are just some very select arguments. All the petitioners are being represented by very eloquent lawyers. I will be making many more videos on the subject, so stay tuned. Bye for now.